Good afternoon, ladies and gentlemen. Thank you for coming to today's hearing. We call this hearing to, based on a resolution which we filed, to look into the position of the BIR and the DOF that we need to relax our bank secrecy laws in order to aid the fight against tax evasion. So that's where we're coming from. And secondly, there's a bill that the BSP is supporting regarding the exemption of sales of gold to the BSP. We'll talk about that second. First, we'll talk about the bill of the DOF. So let's recognize our guests. Let's have the committee secretary recognize our guests, and then we'll ask your opinions regarding this matter. Please.
Good afternoon, Mr. Chair. Welcome to the Senate, our resource persons. From the Department of Finance, we have Yusek Jeremias and Paul Jr. For the BIR, we have Assistant Commissioner Claro B. Ortiz, also the overall coordinator for the Run Against Tax Evaders program. Together with him is Attorney Charadin S. Bandon, Chief of the International Tax Affairs Division, and Attorney Nina Asuncion, Head Legal and Legislative Division. For the Bangko Sentral ng Pilipinas, we have Attorney Elmore Capule with the General Counsel, together with Ms. Chuchi Fonasher, Managing Director for Supervision and Examination Subsector, together with Attorney Arifa Ala and Ms. Siti Butokan. For the Department of Justice, we have Attorney Marlene L. Angeles. For the Department of Foreign Affairs, Mr. Marcos Ponsalang. For the Anti-Money Laundering Council, we have Attorney Vincent Solido, Deputy Director, Compliance and Investigation Group, and also Mr. Arnold Frane of the AMLC. From the Bankers Association of the Philippines, Mr. Arnel Almaden and Ms. Maria Consuelo Hostiniani. For the Rural Bankers Association of the Philippines, we have Mr. Vicente Mendoza, its Executive Director, and Attorney Ruben Purisima, its Legal Counsel. For SGV, we have Attorney Louis Ferrer. From Isla Lipana, we have Attorney Maria Teresa Ledesma. From the Development Bank of the Philippines, Attorney Leilani Capule. Land Bank of the Philippines, Ms. Amelia Amparado. From the Hong Kong and Shanghai Banking Corporation, Mr. Isagani Cortez. From the American Chamber of Commerce of the Philippines and the Arrancada Philippines Project, or TAP, Mr. John Forbes. From the Chamber of Mines of the Philippines, VP for Legal and Policy, Mr. Ronald Residoro. And from the Mines and Geosciences Bureau, we have Engineer Romualdo Aguilos, Division Chief of the Mineral Economics Division. Mr. Chair.
Thank you, Comsec. Again, thank you for coming, ladies and gentlemen. Can we now hear from the Department of Finance? I suppose you have a draft bill. Could you run us through its features and explain to the body what are the safeguards and how it will operate in practice?
Mr. Chairman, we do have a draft bill which was drafted by the BIR. But perhaps, Mr. Chairman, for the details, can I refer you to the BIR representative? But before that, I'd like to premise this on certain things. Two facts. The Philippines is one of 3 countries in the entire world that does not allow its tax administration access to bank transactions. The other 2 are Lebanon and Switzerland. The Philippines is the only country in ASEAN that does not allow its tax administration access to bank transactions. And the Philippines is the only country in Asia other than Lebanon that disallows tax administration's access to bank transactions. On the point on tax evasion as a predicate crime to money laundering, according to our consultations with the bank and the World Bank and the IMF, the Philippines is one of only 2 countries in the entire world that do not consider tax evasion as a predicate crime to money laundering. The other country is Lebanon. The Philippines is the only country in ASEAN that does not consider tax evasion as a predicate crime to money laundering, and the Philippines is the only country in Asia other than Lebanon that does not consider tax evasion as a predicate crime to money laundering. Um, Again, Mr. Chairman, what we're trying to achieve here is that to essentially allow the tax authorities, like in other countries, to look into to bank accounts. Right now, as I understand it, the BIR Commissioner has authority to inquire into bank deposits and other related information held by financial institutions in 3 cases. A dissident as to his gross estate. Number 2, taxpayer has filed an applicant for compromise of his tax liability due to financial incapacity. And 3, subject of an exchange of information on request. So the draft bills that were drafted by the BIR essentially proposes just to amend Republic Act 1405 and essentially adding an exception to the absolute confidentiality of bank deposits, including essentially allowing the BIR to look into this. Perhaps I can ask the BIR representative to elaborate on this.
Yes, go ahead, and please read the actual language of the amendment.
Yeah.
Good afternoon, Mr. Chair. The wordings of the amendment and providing penalty, therefore, is hereby further amended to read as follows. Section 2, all deposits of whatever nature with banks or banking institution in the Philippines, including investments in bonds issued by the government of the Philippines, its political subdivisions, and its instrumentalities are hereby considered as of an absolutely confidential nature, and may not be examined, inquired, or looked into by any person, government official, bureau, or office, except upon written permission of depositor, or in case of impeachment, or upon order of a competent court in cases of bribery or dereliction of duty of public officials, or in cases where the money deposited or invested is the subject matter of the litigation. What we added is, or for tax purposes, implementation of tax treaties or other international tax agreements, subject, however, to the provisions of the confidentiality of information pursuant to Section 270 of the National Internal Revenue Code of 1997. We also increased...
Can you repeat, please? Or for tax purposes, implementation of tax treaties
or other international tax agreements, subject, however, to the provisions of the confidentiality of information pursuant to Section 270 of the National Internal Revenue Code of 1997.
Section 270
Yes, yes,
of
Mr.
the
Chair.
NIRC.
Yes, Mr. Chair.
So let me read it for the benefit of the body. You're just adding on to the last section of Section 2 of Republic Act 1405, or for tax purposes, implementation of tax treaties or other international tax agreements subject to provisions on the confidentiality of information pursuant to Section 270 of the NIRC. Is that correct?
That is correct, Mr. Chair.
Okay. Sige, yung next one sa Section 5.
For Section 5, Section 5 should read as follows. For each act or omission in violation of this law, the offender shall be punished by a fine of not less than 500,000 pesos, but not more than 1 million pesos, or suffer imprisonment of not less than 12 years, but not more than 20 years, or both. Furthermore, any offending government officer or employee shall be imposed a penalty of dismissal with forfeiture of all benefits.
for time for the benefit of the body. Thank you. Isa pang beses, Assistant Commissioner.
Section 5. For each act or omission in violation of this law, the offender shall be punished by a fine of not less than 500,000 pesos, but not more than 1 million pesos, or suffer imprisonment of not less than 12 years, but not more than 20 years, or both. Furthermore, any offending government officer or employee shall be imposed the penalty of dismissal with forfeiture of all benefits.
Yeah, okay. Nakuha ba niya lahat yan? So let me clarify, no? There are 3 amendments there in Section 5. First is the monetary one, no? So from 20,000, you're proposing na not less than 500, but not more than 1 million.
That's
Doon naman
right.
sa kulong, not less than 12 years, but not more than 20 years. So what is that? That's prison mayor or reclusion temporal?
Temporal.
12 to 20. Reclusion temporal, yeah. And an additional penalty of dismissal or forfeiture.
That's correct, Mr.
3.
Chair.
Okay. So those are on the table right now. Could you explain Section 2, the Section 2 amendment? I think the Section 5 amendment is klaro naman yun. No? You want to put more teeth dun sa lalagyan nyo ng ngipin yung batas. Pero dun sa Section 2, why are we limiting it for tax purposes, implementation of tax treaties or other tax agreements subject to provisions of Section 270? Why the particular emphasis on implementation of tax treaties and other tax agreements? And which ones would we be referring to? Can you give us a list of...
May I request the Chief of the International Tax
Sige,
Affairs Division?
go ahead.
Good afternoon, Mr. Chair. Thank you for the opportunity to elaborate on this very important measure that we're proposing. So we are actually pushing for another exception under Section 6F of the Tax Code by expanding the bank exceptions to the Bank Secrecy Law by allowing BIR to access bank information if such access is necessary to implement tax treaties. So let me just go back to what Yusef Paul said earlier, that currently, one of the exceptions now under Section 6F is that we're able to access bank information upon the request of a treaty partner, pursuant to an exchange of information request. So this is in accordance with your exchange of information article of our double tax agreements. So there was an international standard that was created in 2009. It is known as EOI on request, and that standard requires...
What? Sorry?
That standard is called
Known
EOI on request. EOI, which is exchange of information and request. So that standard requires countries to access bank information and to provide it's not just bank information, financial information upon request of a treaty partner. At the time, in 2009, we did not have that authority under the tax code. So what happened was we were included in a blacklist, an international blacklist. We were branded as a non-cooperative tax jurisdiction. And because we were included in this exchange of information article of our double tax agreements. So there was an international standard that was created in 2009. It is known as EOI on request. And that standard requires...
What? Sorry?
That standard is
is it
called
called?
EOI on request. EOI, which is exchange of information and request. So that standard requires countries to access bank information and to provide it's not just bank information, financial information upon request of a treaty partner. At the time, in 2009, we did not have that authority under the tax code. So what happened was we were included in a blacklist, an international blacklist. We were branded as a non-cooperative tax jurisdiction. And because we were included in this blacklist, we also faced some economic sanctions. And there were, aside from that international list, there were 2 country-specific lists issued by Italy and France. So we were part of that so-called tax haven list. So what happened was we amended the law So now we had UN
Sorry to
request.
interrupt. What is the sanction that we were that was put upon?
For example, sir, in the France, the Italy blacklist, there were higher documentation requirements for overseas Filipino workers in Italy, and there was also withholding of investments by their citizens to our country. So there was a decree, I think, issued by the Italian government. So we amended our law. We also renegotiated.
What was the
Amendment,
international sanction? That's the domestic. That's the
That's
sanction by a specific country. But you mentioned some international sanction. International
International sanctions would include also reduction of aid. There was international reputational damage on our country. Withholding also of investments by the compliant countries. So that happened in 2009. What happened then was we legislated EOI and request law, or the RA 121. And with that law, we were empowered to access bank information upon request of a treaty partner. Moving forward, the international community wanted a more robust EOI framework to tackle cross-border evasion. So in 2013, the G20 leaders and OECD leaders, they declared practically for countries to adopt a new standard in exchange of information, which is called the step change in tax transparency, because now bank information will have to be provided not only upon request but automatically. So that was in 2013, and in 2014 it actually became the international standard. That international standard is known as Common Reporting Standard, or the International Standard in Automatic Exchange of Information. So right now there are two standards in EOI, EOI request and CRS, or Common Reporting Standard. So for the Common Reporting Standard, more than 94 countries have already committed to implement the standard, and the first exchange will happen in 2017. For us, Philippines made a political commitment in 2014, and we are expected to do our first exchange in 2018. Actually, we're a bit late because we are a developing country. Doing this entails a lot of resources and changes in our infrastructure and in our administrative processes. But nonetheless, we have committed because it's an international standard, and we don't want to be included in any blacklist again. So it's imperative that we participate in the standard. But what is problem?
Sorry to interrupt again. What did we commit to exchange by 2018? And what were, on your earlier statements regarding the sanctions?
Yes.
You mentioned reputational collateral and withholding of
Investments.
of aid or investments. Could you give us the details of those and the details of the exchange? What information is to be provided?
So do you want a written description of the sanctions?
You could give us a brief description and also a written one. Oh, yeah.
Okay. So, sir, the sanctions included a reduction in aid, withholding of investments, because the
What specifically? Which aid was withheld?
There was no at the time, sir, because the blacklist was issued in 2009, and when we were part of that blacklist, immediately we committed. We made a political commitment to adopt, and then we made the political commitment to adopt the standard. We were moved to a sort of a gray list, so we did not actually experience a reduction in aid. But what happened? At least we experienced reputational damage in the international community already. That was the immediate effect. So now we're moving towards a new standard. As I said, this is called the Common Reporting Standard, and this standard requires tax authorities to exchange financial information on accounts of their non-residents. They will be exchanging this financial information to their treaty partners on an automatic basis. Could be yearly basis. It is standard because the information to be exchanged are common to all participating countries. So that would include the name, the taxpayer identification number, the country of residence, the gross amount of the income earned by the non-resident.
Mr. Chair, we have the materials and we'll be providing the committee the narratives and the description of the standards.
Could you just clarify your statement regarding the information given? Name,
Okay.
TIN, country of residence, income of non-residents. So it only
Yes.
applies to non-residents of
Non-resident.
the requested jurisdiction, not the requesting jurisdiction.
Yes. Actually, in automatic, there will be no requesting or requested jurisdiction
already giving
because it's already
It's a common
automatic.
database. Common
Yes.
database siya.
There will be a common transmission system being developed for this purpose.
Uh-huh.
So,
And this is 194 countries, you said?
94 jurisdictions have
94.
committed.
94 jurisdictions.
And that would include even Switzerland, British Virgin Islands,
This is
Cayman
by
Islands.
20...
The full implementation by 2018, but there are early adopters, and they will be implementing in 2017.
Who are the early adopters?
I have a list of the countries, but for 2017, it already includes British Virgin Islands. If I may refer to my list.
Yes, sure, please.
There's a number of countries. It would include BVI, Bermuda, Cayman Islands, France, Germany, UK, Luxembourg, India, Ireland, Korea, Italy, Liechtenstein, Lithuania, Cyprus, Czech Republic, Denmark, Estonia, Finland, Colombia, Croatia, Anguilla, Argentina, Barbados.
Oh, it's okay. So when we
It's a
say
lot.
non-residents, they're not resident in the country which is providing the information.
So if the Philippines, for example, implements the standards, the financial institutions will collect information on non-residents.
So this is precise, this is more to target offshore money, in other
Yes.
words.
It's
It
a
doesn't really
solution.
deal with tax evasion in a domestic level. Tama ba?
Correct.
Is
Your
that the
Honor.
limitation of the request, Mr. Yusek? Because my impression was that you were after a widespread power to look after, rather not this limited power that the BIR is referring to, na limitado lamang sa pera na hawak ng mga Pilipino na hindi nakatira dito hindi nakatira sa iba't ibang bansa pero may pera doon. Yun ang pagkaintindi ko sa BIR.
Mr. Chairman, if you look at the bill, it says or for tax purposes, comma, that essentially refers to for domestic tax purposes. Implementation of tax treaties or other international tax agreements. That's the other one that was described.
So for tax purposes is a instance where you can, it's not a modifier of implementation of tax treaties. I think you have to reformulate the language, I think, so it's clearer. Huh? Because the impression is that for tax purposes, the implementation of tax treaties or other international tax agreements will be subject to an exception of the bank secrecy. You do not read tax purposes looks like it's modifying you're only asking for an exception when pagdating sa tax treaties. But the phrase for tax purposes, that's very general. What does that mean for tax purposes? Meaning, I'm a tax collector. I want to look into someone's bank account. I can do it because it's for tax purposes. Ano yung safeguard doon? Oh. It's a little too general, I think, for tax purposes.
For tax purposes, it includes the stage of assessment up to the time of collection.
So how many people can look at those accounts then? How many people are empowered to make assessments and collections under the NIRC?
If a taxpayer is issued a letter of authority, then probably that's the start of the...
Oh, let's not have a circular discussion.
Yes.
I'm really trying to go to the kernel of the issue, which is how many people will be able to look at the bank accounts and how widespread is the power and what are the safeguards. That's basically the concern of the committee. So when you answer me na those who are empowered to issue the letter of authority, sino yon? Sino yung you follow it up with who are empowered to issue the letter of authority? Whether it's the RDO or
It's
et cetera.
usually the regional director that issues the letter of authority or the Commissioner of Internal Revenue. For rate purposes, it's the Commissioner of Internal Revenue that issues the letter of authority to investigate a certain taxpayer suspect of a tax evasion.
But who makes the assessment? Di ba sa regional level meron na yan?
There are two. There's a National Investigation Division under the National Office and Regional Investigation Division under the regional offices. There is
How many people could look into the bank accounts under your proposed amendment?
the investigators,
Ilan
Mr.
yun?
Chair.
Ilan yun?
Usually, if, for example, in the National Investigation Division, there's a group supervisor and there are region or revenue officers. And the revenue officers are about 3 under the group supervisor. And
Again, we're going into a very circular type of answer. Eh. Just answer the question like, ilang tao yan?
well, usually,
Oo.
isa lang talaga.
Ilang tao lang? Sa buong bansa, ilang taong kung napasa tong amendment ninyo, how many people in the whole country will be able to look into bank accounts for tax purposes?
For that particular taxpayer, only the group supervisor and then
Hindi. Again, how many? How many?
it's around 3 or 4 for the group. And ang total kasi it goes up eh. I'm sorry.
That's why. Don't expect me to be familiar with something that you're familiar with. Don't expect people around the table to be
sorry,
familiar
Mr.
with
Chair.
that structure.
Let's say for one particular case, it's about 10 persons. We'll take a look at it.
But there's nothing in your amendment which says that would limit it to those 10 people.
Well, we have a safeguard, Your Honor.
What is your safeguard?
This is pursuant to the provisions of confidentiality of information, pursuant to Section 270.
Oh, so how would that amend your proposal?
What do you mean?
270 is what is ang nakalagay sa 270, di ba? Basta nasa return.
Unlawful
Confidential
divulgence.
yun, di ba?
Unlawful divulgence, yeah. So any information that would be gathered or obtained by the, let's say, by the revenue officer will be confidential in nature. It cannot be divulged. And that's the reason why we increase the penalty also.
Okay. But what in this amendment would limit it to those 10 people, di ba?
Your Honor, lahat naman ng mga information that we get, the
10
BAR,
people per revenue district yan.
I'm sorry, yon,
Yung sinabi mong 10 per revenue district yon.
per taxpayer.
Per taxpayer, 10 people will be able to look at their bank accounts.
Yes, Mr. Chair.
And what would be the basis for looking into the bank accounts? Kailan mabubuksan yung pintuan? What is the act that
Upon
would,
issuance of the letter of authority.
issuance of how many LOAs did you issue last year?
For the rate program,
No, total. BIR.
Can we get back to you on that particular?
Just a ballpark figure. You get back to me on the exact figure, but for the ballpark figure, you should have an idea of how many LOAs you issue.
Okay, there's the letter of authority issued for the year 2014 is 31,197.
Okay. So you're saying, under pag pumasa yung amendment ninyo, you will have 10 people looking at those 31,000. So you'll have,
speaking.
kasi per case, di ba?
Yes, Mr. Chair.
That seems to, it seems like a very large number, hindi ba? Parang hindi siya. Well, anyway, let's proceed with discussion. Let's ask the comments of the group. So the reckoning point was basta na-issuean ka ng letter of authority. What is the lowest amount that you had in that letter of authority? Doon sa 31,000. Hindi collected. That you're asking to be assessed. Na magbayad siya ng magkano. Ano yung amounts doon? Ano yung range?
I can only speak for the rate program. It's one
Why
million.
you keep separating the rate program from the rest of the...
Kasi, I have personal knowledge of the rate
sige,
program.
sa rate na lang muna.
The basic tax should be 1 million and up.
Yun ang rule nyo. If it's below 1 million.
Yes.
What happens if it's below 1 million?
That would be given to the Regional Investigation Division for further study
Okay.
and investigation.
Okay. So how many of the 31,000 LOAs fell under the rate?
Well, we filed cases already around 391 or 96, so that's already considered as 396 LAs, and probably pending before the National Investigation Division in other regional offices, I would say around 100.
100 cases pending. Ilang years na ba kayo
Yes.
sa BIR?
Ako po,
Yeah, yes.
16.
16 years. Okay. So, could you tell us the 10 officials na who would look at the bank accounts? Who is the lowest, who is the highest?
The lowest would be the revenue officer, and then the group supervisor, assistant chief, the head revenue executive assistant, the assistant commissioner, the deputy commissioner for legal, and then the commissioner.
That's only 6 officials. Because you're saying there's more than one assistant
Yes, but
commissioner.
I just said
Rough
one.
lang yung 10. Rough
Yeah.
lang. So, revenue officer yung pinakamababa.
Yes, Mr. Chair.
What's the requirement to be a revenue officer sa BIR?
He has to be a CPA.
CPA. And any work experience needed?
No,
Wala.
no.
Wala.
Pwedeng-
Basta CPA coming in from...
Yeah, entry level would
one of
be
the firms, pwede.
CPA. Yeah.
What is the salary grade for the lowest salary grade for a revenue officer?
Grade
11. So
SG 11.
SG 11. Ano ba yan? 16,000? Something like that?
Magkano yung SG 11?
Hmm? Yeah, that's about 16,000.
It's about 13,000. Mas mababa pa yung sa BIR.
Okay. Sige. Any other comments from the... Alright, sige. Any other comments before we move on to the other resource persons? You want to wrap up? Oo.
What was read to you on the amendment was only for the Republic Act 1405.
Wala pa
There's
yung
a-
sa money laundering
Wala pa
law,
yung
no?
money laundering. Dapat
Yeah.
i-describe mo yung money laundering.
Yeah. Kasi magka ano yun, di ba? Magkakapatid yun. kumbaga.
Magkakapatid yun eh.
Ah.
Ito to.
Uy. Like to recognize the candidate for the highest office of the land, Senator Grace Poe. Thank you, ma'am, for coming.
This is Mr. Gary Cortez of HSBC. Just have a query. Is there also a proposed amendment for the Foreign Currency Deposit Act? Because that's only with regard to the Philippine deposit.
Yeah, probably because FCDUs kasama dapat, di ba? Kasi hindi lang naman. Oh, okay. Sige. Okay, go ahead if you have anything to say about the money laundering.
Another bill is proposed by the another bill proposed by the Bureau of Internal Revenue is the Act further strengthening the anti-money laundering law, amending for the purpose Republic Act number 9160, otherwise known as the Anti-Money Laundering Act of 2001 as amended. Actually, there's only one amendment being introduced, and that is to include tax evasion under RA 8424 as amended as one of the predicate crimes for money laundering. And the reason for this is the FATF recommendation, which was issued in, maybe Yusuf Paul can, okay.
Section is the, ano? What section are you amending?
Section 3, paragraph I, item 14 of Republic Act number 9160 is hereby further amended and renumbered as section 15.
So that would be number 15.
Yes, and further amended as follows.
Ano yung ano na lang? Ano
So
yung
under
number 15?
letter I, novel activity, number 14 is tax evasion under RA 8424 as amended.
I have section 14 is already felonies or offenses of a similar nature. You would push it in ahead of
Yes.
ahead of ano? Ahead
Yes,
of
we
that.
will just renumber.
Okay, renumber. So what would the language be?
So there will be a number 14.
Yeah.
And that is tax evasion under RA 8424 as amended. And then we renumber the old section 14 to 15.
Tax evasion under 8424. Any other amendments under 9160?
That's all for the law.
Okay, so do you want to say anything in support of your proposal? How specifically it helps you pursue, ano? Maybe sa amin, kung kailan kayo napigilan ng batas na, kunyari na dead end kayo, di ba? May leads na kayo, tapos, mas maganda yung ganun. Para ma-picture natin, yeah, we can see the law in action, kumbaga.
Probably can cite an example or a theoretical
Actually,
situation.
no names, just an example, and goes through. You filed the case, etc.
Yeah. If, let's say, a taxpayer is being investigated by the BAR, they will look at the income tax returns and determine the income that they have or disposable income that they have. And upon investigation, let's say we discovered that he purchased real properties and personal properties in the amount of, let's say, 100 million. But he only, for the span of 5 years, let's say, but he only declared also income in the span of the particular 5 years, only 10 million. So there's a discrepancy of 90 million. So where did that come from? So we can trace the money where it went. If, let's say, we have an exception to the bank secret, so we can take a look at the bank accounts and see if there are monies involved there, and we can also trace the cash flow of that particular taxpayer.
Mr. Chairman, my question would be this. I understand go after those that do not pay the right taxes. But what is your tolerance? Because as you see, sometimes ordinary citizens will also at some point have conflicts with their tax returns. And I think that we need to be very careful that this particular amendment, if indeed it passes, wouldn't be used as a way to harass a particular person or a corporation. What is your tolerance? Like how many percent, or perhaps a repeater of a repeat tax evasion case, etc.?
Madam Senator, under the tax code, if there is a 30% under declaration of income, that would be considered a prima facie case of fraud. And that's our barometer or parameters in investigating a person.
Una nyo yun?
Yes.
Una nyo, pag may 30%.
Yes, Mr. Chair.
But regardless of the amount.
Regardless of the
Like
amount.
maliit siya. Kasi
Yes.
may 30% of 500,000. I mean, your cost of prosecution wouldn't even justify the running after it, di ba?
Well, that will be also considered in our collection of the taxes.
Kasi tingin ko in these cases, you must also protect the smaller guys who can no longer hire lawyers, etc. Di ba? Maybe an innocent mistake also.
Yung sa stage po kasi ng investigation, if they deemed na, okay, we would just pay the amount, then we allow them naman.
Yung the case example you gave us, Assistant Commissioner, yung 90 million, that's a prima facie case, di ba? Of tax evasion. Kasi,
That is correct.
oo, more than 30% yun di ba? Bumili siya ng 100 million property, di ba? Tapos, 10 million lang ang dineclare niyang income.
Yes,
Why,
Mr. Chair.
I'm just wondering, in that case, isn't that an open and shut case already for the BIR? Parang,
Yung criminal
I
aspect
mean,
po,
unless makapresent ng defense yung defendant na he had income from the stock market or from bonds or whatever, that's passive income, whatever. Yun na lang siguro ang defense niya, di ba?
Yes,
Na
but
meron siyang, or kaya may minana siyang pera.
yung,
But I don't. Why does the looking into the bank account become crucial in that case?
mahirap po kasi talagang to prove yung tax evasion because that's not documented actually. So with the documentation together with the bank accounts, we can prove beyond reasonable doubt the guilt of that tax evader.
Mm-hmm. Oh, that's criminal liability beyond reasonable doubt. Pero hindi ba madaling i-prove with respect to civil liability just for collection? Kasi hindi ka nagbayad.
For collection po, pwede po. But for criminal purposes, medyo mahihirapan po kaming to prove our case without any documentary evidence.
Mm-hmm. Mm-hmm. Sige. If there's no other comments from the BIR and DOF, we'll move on to the other resource persons. Yeah, go ahead, you said.
Just a quick comment on the question of Senator Grace po. From a practical perspective, from a risk management standpoint, I don't think BIR will focus on the small guys. It will really be the big ones, eh? And these are the big guys are the ones who also have money abroad, who have the capacity to hide. So the majority of the Filipinos should not worry about this.
Track record, lahat hinahabol nyo eh. Hindi lang naman malaki hinahabol nyo, di ba? Eh, pati co-ops, hinahabol nyo. Di ba? Pati marginal income earners, hinahabol nyo eh.
So we should put safeguards.
So hindi lang, buti kung you have a track record of just going after the big guys, but you
Pero
don't.
what we can agree on a threshold, but clearly that can be discussed.
Yeah, I think a threshold might not be a bad idea actually, because you have to justify the cost of enforcement also. Something that we never take into account actually, but so maybe if you're done, we'll go to DOJ, then they can tell us also. DOJ, and then AMLAC siguro. Unless mo gustong mauna nung AMLAC. AMLAC na lang muna, sige, since you're really the subject.
Mr. Chair, good afternoon. Insofar as the AMLAC is concerned, we fully support the proposal of the Bureau of Internal Revenue to include tax evasion as one of the unlawful activities under the anti-money laundering law. If you may know, Mr. Chair, under the recommendations of the Financial Action Task Force, tax crime is one of the designated categories of predicate offenses under the for money laundering. But if we are to amend again the anti-money laundering law to include tax evasion, may I suggest also that I take note of Section 20 of the anti-money laundering law, and it states there, if I may, Mr. Chair. Section 20, non-intervention in the Bureau of Internal Revenue operations. Nothing contained in this act, nor in related antecedent laws or existing agreements, shall be construed to allow the AMLC to participate in any manner in the operations of the BAR.
Can you? I seem to have an old copy. I think my staff gave me an old copy of the
Section
91. Is that a
20,
new provision?
as
Sa money
amended,
laundering?
Mr. Chair, last 2013 in March.
That's the most recent amendment
That
of
is
the...
correct, Mr. Chair.
Okay. Can you repeat it? I'm sorry.
Section 20, non-intervention in the Bureau of Internal Revenue operations. Nothing contained in this act, nor in related antecedent laws or existing agreements, shall be construed to allow the AMLC to participate in any manner in the operations of the BAR.
Okay. Why is it necessary to have that provision?
You
You cannot share information between the two
That's
agencies.
correct.
Is that what it means?
Correct. Because in order to successfully prosecute money launderers, Mr. Chair, we have to coordinate with the Bureau of Internal Revenue for their records. Because if we are to file cases for bank inquiry,
So we need to remove that provision.
that is correct, Mr.
In other
Chair.
words,
Yes.
okay. And that's not being removed in the amendment, in the proposed amendment. Tama ba? Yeah, it's not. Wala yun sa, ano nyo, sa bill nyo, di ba? It should be. Okay,
Yes,
so you
it should-
agree.
it should be
You
included,
agree
yes.
with that?
We agree.
Okay. Yeah, that's what I was thinking. You should be. I mean, it's funny if one agency can look into accounts and one can look into another, but you cannot talk amongst yourselves.
Correct.
Diba? You're on the same side. Kumbaga. Oo.
That
Sige,
is
go
all,
ahead. Good.
that is all insofar as the AMLC is
Or,
concerned.
but
Mr.
maybe
Chair.
you can provide us with why was that? Is that a recent amendment? That's not in the original law?
That was not in the original law, Mr.
Oh.
Chair.
Okay. And when was that amendment made?
Last March 2013, Mr. Chair.
Okay. Very recent amendment, no? What predicate crimes did we add in 2013?
There were 22 predicate crimes added, Mr. Chair.
Mhm. 22.
22, Mr. Chair.
Okay. Dito lang sa section 3I, ano yung mga luma dito?
1 to 14. It's the old one, Mr. Chair. The 15 to the rest, it's the new amendments in 2013.
Okay. Okay. So maybe tell us a little about how you think this can help you, Sarah. Kamusta ba ang implementation ng anti-money laundering?
Well, we have been effectively implementing, Mr. Chair, the provisions of the anti-money laundering without fear or favor.
Ano yung which ones led to the most leads or prosecutions? dito?
Mr. Chair, so far we have, insofar as drug cases are concerned, graft and corruption, and pyramiding scam. Those three, Mr. Chair.
Yung pyramiding, where does that fall under?
The violation of the securities code, Mr. Chair.
Yung sa drugs, ano yung...
Number two,
number
Mr.
two,
Chair.
no? Yeah. 3, 4, 5, 7, 8, and 9 of Republic Act 764. That's the chair. That's the committee chaired by Senator Poe. So nakatulong talaga sa prosecution ito.
Yes, definitely, Mr. Chair.
How about recovery of monies?
Yes, Mr. Chair. In fact, we have already remitted billions to the National Treasury.
Magkano?
The last time, if ballpark figure, Mr. Chair,
Yeah,
I cannot
sure,
recall, it's about 4 billion, Mr. Chair.
4B. How many cases yon?
That's about, more or less, about 30 cases, Mr. Chair.
Cases. How often did the AMLAC have to look into bank deposits? Meaning, kung wala yung exception dito, ilan beses nyo tinignan yon?
It depends actually, Mr. Chair, on the number of cases referred to us by our law enforcement authorities, as well as the based on the suspicious transactions submitted to us by the different covered persons.
So ilan yon?
So for 2014 alone, Mr. Chair, the suspicious transactions provided to us by our covered persons is about 97,000 suspicious transaction reports. For 2012, there were about 19,000 suspicious transaction reports. For our law enforcement authorities, more or less for 2014, they have referred to us about 100 cases, Mr. Chair. 100 cases.
100,000?
100,000. No, 100.
Just 100 cases?
Yes, 100 cases.
So what was the 97,000? 2013 yon?
2013, Mr. Chair, mostly as a result of the pyramid scam and the PDAP scam, Mr. Chair.
So just to get it straight, 2012, 19,000 reports.
No, yes, Mr. Chair.
2013, 97,000
Correct.
reports. 2014, 100 cases. Iba yun sa
No,
report.
no, that's different.
Oo.
We are referring to the suspicious transaction. Now, for the cases referred to us by the law enforcement authorities, it's about 100 cases.
Okay. What's the 2014 figure for suspicious transactions?
We have not yet come up with, I will verify, Mr. Chair, with our office on the number.
Sige. Okay. How about the DOJ? Anong comments niyo dito sa proposal ng...
Thank you, Mr. Chairman. We also share the views of expressed by the Bureau of Internal Revenue as well as the Anti-Money Laundering Council Secretariat that there may be a need to include tax evasion as an exemption to the confidentiality rule under the Bank Secrecy Act, as well as for the amendment of RA 6426 insofar as foreign currency deposits are concerned, and also for the inclusion of tax evasion as a predicate offense of money laundering. Thank you, Mr. Chair.
Thank you. Can I go back to the DOF and the BIR? What is your estimate of revenue that you can recover for the state if your amendments are passed into law? And after giving a number, explain to us how you got it.
Mr. Chair, can we wait for Yusek Paul to...
He has the
he has
data.
the
Oh, sige, sige.
Thank you.
West. Which one do you want to hear? Let's call them first. Okay. For the business side. For the business group dito. Sino ang business group dito? Let's hear from the private sector maybe to get a balanced feel for the bill. Maybe any business groups here? Business groups represented? Well, HSBC is a private bank, no? But we'd really prefer to hear from... Yeah, sige. We'll call on HSBC and then AmCham, I think, and then SGV. So HSBC, go ahead, yeah.
HSBC is always in favor of tax transparency, and we are against tax evasion. And this is a global policy of HSBC, not just in the Philippines, but everywhere where we operate, Mr. Chairman.
Okay. Are you a group mate of Mrs. Purisima? In the back?
That's correct, Mr. Chairman.
You're a group mate. Okay. Mr. Forbes, yeah?
Thank you, Mr. Chair. Just in general, we made a statement last week in which we supported a reduction of corporate and income taxes and in turn increase in some excise taxes. But in that context, we also expressed general support for amending the bank secrecy laws, both the current law just discussed and AMLA and also the one on FCDU. But not the specifics. This is the first time we've heard the specifics, and in general they sound very sensible. I just don't think the Philippines should be an outlier when it comes to international agreements, right? To be in a party of two or a party of three.
Yeah.
Thank you.
Could you share the American experience maybe with us regarding the IRS and what their powers are?
I haven't researched it, but if you give me some time, I'll try to get
that. That would be great, actually, because well, it's known to be a jurisdiction where there's quite solid revenue collection, so we'd appreciate it.
Yes, I'm personally aware of that.
Right. Okay. SGV. Attorney Ferrer.
Mr. Chairman, this is actually the first time that we heard about the specific provisions proposed by the BIR to amend the Bank Secrecy Law. And we propose to submit our written comment seeing the written provisions.
No initial comment based on what you heard?
But initially, in general, in principle, we do not have any objection, subject to the appropriate safeguards that will be provided.
Okay, thank you. Any other private sector groups who are here and would want to? Yeah, thanks a lot. What do you have? Bankers, yeah, BAP. Yeah, go ahead, sir.
The BAP, thank you for inviting, Mr. Chair, the BAP to this committee hearing. We actually we welcome the initiative to finally revisit the Bank Secrecy Law. But in the meantime, we would await for the details before we can come up with a industry position. In the meantime, we have started the ball rolling and we are
to consult among your members.
36
all right,
member banks.
How much time do you need to come back to us?
2 to 3 weeks normally.
2 to 3 weeks, okay.
But we don't have the copy yet of the proposed amendments.
Ito na.
Yes.
You'll be given a copy after
yes,
the...
Mr. Chair.
How about the BSP? Can we hear from the BSP?
Yeah, thank you, Mr. Chair. As a matter of principle, the BSP supports amendments to liberalize or relax our bank secrecy laws. As a matter of fact, even the BSP is covered by the bank secrecy law such that we cannot even look into the deposits of banks even if there are anomalies or fraudulent activities. However, Mr. Chair, with respect to the details, as stated by others, we have just seen the draft today, so we need some time to come up with our more specific comments on these details. Thank you, sir.
Thank you. Aren't there existing principles of law where you are empowered to look into bank deposits? Ito, it's into your periodic special examinations to ensure compliance with the AMLA in accordance with the rule of examination of the Banco Central. And secondly, to conduct annual testing which is limited to the determination of the existence and true identity of the owners of numbered accounts.
Yeah, actually, Mr. Chair, these are very general provisions. It treats more of sampling to determine whether or not there is compliance or non-compliance. However, when we look into specific accounts, specific transactions, we don't have that authority. Under the old charter of the central bank, the old central bank was given the authority to look into deposits if there are fraudulent transactions. However, that was totally deleted or superseded when they passed our new charter. So as of now, we have very limited legal basis to look into deposits.
In terms of tax evasion, wala naman kayo masyadong role sa, di ba? Sa processing of cases and facilitation.
No, Your Honor, we defer to BIR.
Okay. Thank you. Can we hear from the Department of Foreign Affairs? Yeah, Mr. Punsalan. Yeah.
Thank you very much, Your Honor. We already submitted our position to our DFA Legislative Liaison Unit, which was in turn forwarded to you. I will just read, sir. Yes. The DFA supports measures that can deter possible tax offenders as well as expose schemes being used by money launderers and other criminals in financial areas. In serious tax evasion cases where provisions of the Bank Secrecy Law will be lifted, the DFA supports the establishment of procedural safeguards to protect the bank depositor from undue or unwarranted intrusion. Further, the DFA recommends the imposition of penalties for any unauthorized release of confidential and private bank-related information by any individual or agency involved in the subject case. Also, since it was mentioned that the significance of the multilateral competent authority agreement on automatic exchange of financial account information in establishing transparency, we recognize this, but we defer to the wisdom of the BSP and the DOF on whether or not to become a party of the MCAA. The department nevertheless encourages the establishment of institutional mechanisms for exchanging of information to cultivate legal transparency and good governance. That is all, sir.
Thank you. Can we hear from the rural bankers? Either Mr. Mendoza or Attorney Purisima.
Good afternoon, Mr. Chair. We have already submitted our comment on it. Of course, the RBP agrees that tax evasion is a serious crime. But in the same manner, we also would like to make sure that safeguards are in place so as abuses are not committed, no? Anyway, we are only aware currently of the proposal, so we will distribute it to our members for comment.
Okay. Attorney Purisima?
When you received the invitation...
In relation to the Finance Secretary?
Yeah, he's my nephew.
Okay.
So when you received the invitation, what was indicated there was that all of these amendments would have something to do with the lifting of the Bank Secrecy Law, insofar as serious tax evasion cases are concerned. But from what I've heard from what was said today was that there's really no definition at this time, but serious tax evasion cases would include, and based on what was discussed, it would seem that anyone who is subject or there's a suspicion as to his filing of income tax can be subjected to the proposal at this time. That would be all.
Yeah, that's a good point. The original was it's to catch serious tax cheats, di ba? Pero the way it's phrased, it's a lawyer would use the word overbroad. Parang overbroad siya. How do we? Is there no amendment to narrow it down to, in terms of personnel who can peek into the and then in terms of the seriousness, the gravity of the offense? So you really waive it in terms of really the big violators, di ba? Rather than just anybody, because then, if you take what Justice Holmes said is the bad man's view of the law, you can use that power for pangingikil talaga, di ba? Pwede yung extort. Can be used for extortion. Di ba? Takutin nyo lang yung mga somebody who will just say, I'll just pay na lang. Ayoko madistorbo dito sa ginagawa ko. So can we, anyway, we're going to have more hearings. Yes. Can we see how the BIR and the DOF can further streamline and...
We'll take that under advisement,
Mr. Chair. I think in its current version, it's a little... medyo malawak siya. Imagine 31, that means in 31,000 cases, you have potential for abuse also in 31,000 instances, no? Siyempre, hindi naman lahat doon will be amenable to going to court, di ba? Meron diyang will just buy off a quiet life, di ba? So, Tataka ko ba't meron tayong Mines and Geosciences Bureau? Ha? Okay. May comments ba kayo sa lifting ng bank secrecy? May comments ba kayo sa lifting ng bank secrecy? Wala naman, okay. Alright. O nga, nakalimutan ko, may isa pa palang bill tayo. Let's ask Land Bank and DBP. Oo. Anong opinion nila?
Good afternoon, Mr. Chair. Being a government financial institution, of course, we support the initiative of DOF, but of course, we're also a member of BAP, so we will also submit our comments to them for consolidation and submission to the committee. Thank
Iba
you.
ba yung comment nyo sa BAP?
Hindi po naman.
Dun sa comment dun. Okay. Sa DBP naman, same position.
Same thing with what Landbeck had said, but I have a clarification with respect to the amendments presented just now. The amendments, if it's one of the unlawful activities under the anti-money laundering law, it is subject to court order. But if it's an exception under 1405, it's not subject to court order. So we should reconcile that.
Whichever is the easiest way, that's where the government will proceed, di ba? Like if the BIR doesn't need a court order, obviously they'll do it. If they need a court order, they'll ask the BIR to do it, and then they'll just share the information. I think that's the practical answer, di ba?
Yeah, but in the declaration of policy of the anti-money laundering law, the protection and preservation of the integrity and confidentiality of bank deposits still recognized.
Right.
That's why it's still subject to the
Would you care to
ex parte
comment on the
court
point
order.
of the DBP?
As I've said,
Both the
in
AMLAC
the
and the
declaration
BIR,
of policy of the anti-money laundering law, it is stated there that to preserve and protect the integrity and confidentiality of bank deposits. So most of the unlawful activities, it's subject to the ex parte court order.
Yeah, AMLAC, go ahead. Comment, please.
Mr. Chair, if the Bureau of Internal Revenue is given the power to look at the bank accounts, then insofar as the AMLC is concerned, there's no more point for us to inquire into the bank accounts. We will just secure the records from the Bureau of Internal Revenue for the purposes of filing a case for money laundering.
But would that be a violation of the 270? The fact that you gave it to AMLAC? Wouldn't that be a violation? Kasi you have a pending case.
If you're saying that tax
I'm just wondering if it would be. Kasi may naglagay kayo ng phrase na subject to the confidentiality requirements of Section 270 of the NIRC.
That is correct, yeah.
So yung pag binigay nyo, pag pinasa nyo information dun sa kanila,
Baka,
would that be a are you a lawyer?
Yes, Your Honor.
Would that be a violation of the...
That would depend on the construction, Your Honor. If it's tax evasion filed already in court, then that will be considered as public record.
Okay.
So that we can already transmit the records to the AMLAC.
Okay. So once you file the case in court, wala na. 270 does not apply.
That's public record already.
That's public record. Okay.
Mr. Chair, the only time, of course, the MLC can go look into these records or to these bank records is that if we want to follow the money trail, we want to determine who actually is the beneficiary. While the company may have evaded taxes, well, we want to look at to whom or to what company it went to.
Yeah. For purposes of
filing a case for money laundering, because in the case for money laundering, there are several instances where you can commit money laundering.
Right. So in the case, for example, not necessarily yung tax evader ang habol nyo.
Correct.
Sino pa ang pwede nyong habulin doon?
Those who may have assisted, abet, or
may
counsel,
violation
yes,
yun.
Mr. Chair.
Okay. So, kumbaga, they benefited from the proceeds,
Yes.
legal proceeds.
And it's also possible that the money may have been wire transferred abroad, so we can always use Section 13 of the Anti-Money Laundering Law to go after the proceeds abroad.
Okay. So, are you satisfied with the answer that they gave?
I think there's still a need to reconcile it
Because
one does not require court order where the other one requires.
so is that for sake of consistency? You just want them to be consistent.
And the depositors of
Yeah.
banks, especially, especially their lawyers, will look into that technical question.
Okay. And what is your recommendation?
I I think we better follow what is provided in the AMLA if it's subject to a court order, even if
So you
it's an
prefer
ex
that
parte.
there be a court order, even in the case of the BIR? There is a
Yes.
court order. What do you say to that? Yung sabi niya na dapat
Because
may
if
court
we will
order.
include that as an unlawful activity, to be
Well,
consistent
if you look at
with
the other exceptions of the money laundering law, you do need a court order, di ba? Like if it's subject of litigation.
except some cases like
Yeah.
kidnap or ransom.
So, any comment, BIR?
Actually, the administrative...
Would that make it, how would that affect your efforts pag kailangan pa ng court order?
It might be too late, frankly speaking, Mr. Chair.
Because? Explain, please explain. Yeah,
Well,
because you already know things that we don't know.
when we try to investigate persons, and then usually because of the LA or the letter of authority, they are already aware that they are being investigated. And if they want to remove or withdraw the money right away, then we can't anymore go after the bank
But
deposits.
there still be a record, di ba? Even if you get, if you subsequently get the...
This is for collection purposes already.
But if you subsequently, sabi mo, na ano na yung,
Wala-
nalipat na
wala
yung
na
pera.
nakukuha yung-
There is no instrument in the law na tutulong sa atin na, kasi
to collect the civil
a
liability.
few months down the line, malaman natin na we get the
Yeah.
court order and we say, nag-withdraw siya ng ganito, nilipat sa whatever, tax haven. Meron pa ba, wala ba, where can they possibly transfer in the world na hindi na mahabol? Kasi don't we have treaties for that?
Lebanon yata.
Can you give us a list of jurisdictions na pwedeng habulin, yung mga hindi pwedeng habulin? Ano yung...
I think there are fewer places in the world to hide their money because 124 countries are implementing EON requests, and then for automatic EON, 94 countries have already committed. So, there, like, I don't know, the moon.
So yeah, but the point I think of Attorney Capula is that there's the safeguard. When you have a court order, there's due process, di ba? I think that's her point. There's a problem.
Mr. Chair, I think to be consistent with their suggested 1405 amendment, it may be included as those in the unlawful activities not subject to court order, like kidnapping for ransom, etc. To be consistent with the other amendment.
So you're saying now you don't need a court order?
If in the amendment, there is no need for a court order, if it will be included in the exceptions to the court order.
No, but I asked you a while ago, what's your recommendation, and you said that it's better to get a court order. That's why I threw it back to the BIR.
No,
are you now changing your position that it's better if there's no court order?
When they answered my reaction, on the second thought, to be consistent in the two amendatory laws, it should be included in the exceptions to the court order if they want to push through with their intention.
Yeah, for consistency's sake. But I guess now the discussion has moved beyond that. The discussion is now towards actually the nuts and bolts of recovering the money.
Yes, and to comply with the international standards.
Yeah. And
Mr. Chair.
Wala bang ano dito?
Mr.
Civil
Chair.
rights, mga civil rights. I'll recognize you after. But wala bang mga civil rights dito? I think in the next hearing we should invite civil liberties groups, assuming there are some, in the country. Yeah, Isla Lipana.
Attorney Ledesma from Eastern
Attorney,
Lipana
go
and
ahead.
Company. Mr. Chairman, we would just like to emphasize that nothing is more personal than your bank deposit. I mean, it determines how much it's like how much money you keep in your pocket. It's so personal that it can give someone take a second look at you or bypass you. And the power to tax is also so powerful that it can destroy. So given that combination, we would like to see the details as to how the law, more safeguard measures and the details as to how the law will be implemented, because combining, the deposit, which is so personal to an individual, and the power to tax, it can be used to harass. In the ideal world, we support tax transparency and good governance, but this is sadly our implementation in the Philippines is something that we should keep working on. So we're just we would just like to see more of the details on how we can safeguard.
Can Can you add safeguards, possible safeguards?
Well, for one, you've mentioned and highlighted earlier, Mr. Chairman, that as to who should be making the inquiries and to whom the inquiry should be directed. From a bank-wide level, let's go to a universal bank scenario. Some have 700 branches.
What do you mean to whom should it be directed? It's either the bank or the individual, di ba?
Yeah, Mr. Chairman, since well, the BIR would also make direct requests from banks in certain circumstances to make disclosures with regard to certain bank deposits in those permitted instances, and it has always been directed to the head of the bank, the chief legal counsel. So in the context of this law, when the BIR would inquire, would the taxpayer be given prior notice, or can they make the inquiry directly to the bank? To whom in the bank should the notice be given? Can the BIR give it directly to a typical bank manager? And who should make that request? Should it have the approval of the Commissioner of Internal Revenue? Because a bank deposit is so personal to an individual.
Okay.
Can we respond?
Maybe we'll ask for a response from the part of the BIR.
Thank you, Mr. Chair. I'd like to respond to that. At least for the international aspect of this, confidentiality is actually one of the building blocks of our CRS, the Common Reporting Standard. And there's so much importance given to confidentiality that the international group monitoring the progress of countries on tax transparency is conducting a review process of the confidentiality and data safeguards of each tax administration. So for us, BIR has to meet these international standards, and they are first world standards. So that would ensure that the data we collect from banks are just transmitted in the proper channels. Number two, that they are not disclosed improperly, and that any violation of this disclosure rules would have to lead to penalty, the imposition of penalties and sanctions. So we are very strict. We adhere to international standards on confidentiality, if that's the issue in practice.
Just a clarification, Mr. Chairman. Will the standards just be part of the implementing rules?
Sorry, what did you say?
Will the international standards that the BIR would adhere to, would it be codified also?
You mean,
or it will just be part of the implementing rules?
Sir,
We certainly don't intend to legislate on that, no? Or just
Yeah,
limited to the
exactly.
proposal here.
It's
in
implementation
front of us,
already,
yeah.
but maybe you could, there is a document, it's the Standards on Automatic Exchange of Information.
Yes.
It's downloadable. You can read on the standards. We adhere to these standards. We will be checked in implementation if we really do this in practice. Otherwise, we will not pass the international review process, and that's not going to be good for the country. So, if you could find comfort in that in implementation, we will be doing what the standard requires of us.
What about requiring each request for bank information to be signed by the commissioner as a safeguard? Is that impractical?
In international
Rather
law,
than just put the power into each regional officer?
Sir, currently in the EON request, when we do access bank information, the letters are signed by the commissioner.
In
So
practice?
it goes up to the commissioner. But sometimes it's also difficult because we have timelines in the international setting. You have timelines. Sometimes the going up the ladder is, consumes a lot of time. But we, for now, it's a commissioner. So she knows.
Yan, sa exchange of tax information.
Yeah. Yes.
Okay. Since the law was passed, yung 121, how many exchanges have we made?
We do not make a lot of outbound requests. We process a lot of inbound. So I think around 30 already. But for that, we have a profile as to the type of information.
We have no outbound. Hindi tayo nag-inquire sa pera
We
ng
do
mga
not.
Pilipino abroad.
We do not.
How many? How many did you make?
For this year, it's just, I think, 4 to 5. But last year, we made 10 to 13, and most of them were in support of the tax evasion cases.
Why is that? Why don't we make too many outbound requests?
I think because it's a new program, number one, so it's we're still building up the knowledge of the people. Number two, we are domestic tax evasion is a big problem, more than cross-border. So I guess before we look at the international evasion, we have to.
International accounts would furnish you the proceeds, di ba?
Yes. Also,
that's the hiding place, di ba?
Mr. Chair, what we're doing now is we're educating our revenue officers to use the program.
But when you say domestic tax evasion is the priority, dito ba sila magtatago ng pera o sa ibang bansa? If you evaded taxes.
Well, because of the Bank Secrecy Law, dito tinatago din.
What is anong results nung outbound request that you've made? Has it resulted in some progress in certain cases?
There is one specific case, and we've highlighted this in international report. We were not able to, until this exchange of information came, we did, in just one case, detected 240 million peso worth of tax liabilities, and we were actually able to collect on that particular case. That's around $6 million. So that income, the taxpayer had his financial.
Ang utang sa gobyerno.
It was undeclared in the financial statement, in the income tax return, but because we had this EOI program, we were able to.
Corporation yan. It's a corporation.
So even if
and you were able to file a case.
Yes.
Yeah. Nagsettle sila. They settled.
Compromise.
Or it's pending. It's a pending case.
It's a pending case.
It's a pending case. Okay. Yeah. Attorney.
Yes, Mr. Chair. In relation to the clarification by Attorney Capule, and I think it's a point also to ponder insofar as the Bureau of Internal Revenue is concerned. If the tax evasion is made a predicate offense, we have to consider that under the anti-money laundering law, we have the power to freeze and to file a case for civil forfeiture. Now, who will file the case for civil forfeiture? The AMLAC, or is it the Bureau of Internal Revenue? And we also have, again, we have the power to freeze the bank accounts.
It's a good point. Huh? Oh. What is the view of the BIR?
Well, Mr. Chair, we don't have the power to freeze the bank accounts unless the.
Yung point niya, who will file the case
for civil forfeiture? If it's a civil forfeiture, Your Honor, I think it's the AMLAC kasi we only file cases civilly for the tax due.
Wala pa kayong, is it conceivable to file jointly? Ganon? To build up the case and file jointly? Right. Okay.
Under Section 20.
Yeah. For safeguards, who will the non-abuse of authority in case the bank accounts will be looked into by the.
We have the service. If there
serves precisely to be able to withstand any shocks as well as extraordinary demands in foreign exchange. Now, a substantial portion of our reserves comes from gold. Previously, we were monitoring that we had a good collection with respect to sales of gold coming from small-scale miners. As a matter of fact, there's a specific law, the Small-Scale Miners Act, which precisely mandates that the produce of small-scale miners should be sold to the central bank. And the philosophy behind that law is to strengthen the ability of the BSP to be able to buy gold from small-scale miners so that it will form part of its reserves. Now, a few years ago, more precisely in 2011, there were serious efforts by the BIR to tax excise tax as well as withholding tax from small-scale miners. Now, when the BSP started implementing this law, we saw a dramatic decrease in the volume of gold being sold to the Bangko Sentral ng Pilipinas. As a matter of fact, from a high of 32.6 tons of gold in 2005, In 2014, it dwindled to 0.6 ton. So it's a very dramatic decrease. And
The original figure, oh?
in 2005, we were we were buying 32.6 tons of gold
A year.
Mr. Chairman. Yes, a year. Now in 2014,
Two
it's
tons
down
na
to
lang.
0.6, not even 1 ton. And unfortunately, this gold appears to be smuggled out of the Philippines. So other countries are benefiting from this gold and not the BSP. Now, in terms of strengthening foreign reserves, gold is the best because you use peso to buy gold. Unlike if you will increase your reserves using foreign currency, you have to use foreign currency to buy another foreign currency. So in effect, we have a built-in mechanism to strengthen our reserves just by buying gold from the domestic market. So we were able to
Is that the only way of increasing your foreign reserves? Through peso purchases? Is that the only way?
No, actually, there are many ways, Your Honor, but as far as we are concerned, this is the cheapest way.
Could you
of
give
doing
us
it.
the... it's the cheapest, okay. But could you give us the other ways of increasing your... What are the different ways of increasing your foreign reserves?
The Director City can answer that.
Yeah, and these questions can be answered by anybody. Just feel free to pass it on.
Yeah, thank you, Your Honor.
Mr. Chair, in terms of increasing the GIR is actually mainly coming from the inflows, let's say from remittances, from our exports receipts, and the like. So, but in terms of the gold, if we use pesos to buy gold, that will increase the GIR. But as Attorney Capuli has said, if we buy gold,
our reserves just by buying gold from the domestic market. So we were able to
Is that the
identify.
only way of increasing your foreign reserves? Through peso purchases? Is that the only way?
No, actually, there are many ways, Your Honor, but as far as we are concerned, this is the cheapest way.
Could you
of
give
doing
us
it.
the... it's the cheapest, okay. But could you give us the other ways of increasing your... What are the different ways of increasing your foreign reserves?
The Director City can answer that.
Yeah, and these questions can be answered by anybody. Just feel free to pass it on.
Yeah, thank you, Your Honor.
Mr. Chair, in terms of increasing the GIR is actually mainly coming from the inflows, let's say from remittances, from our exports receipts, and the like. So, but in terms of the gold, if we use pesos to buy gold, that will increase the GIR. But as Attorney Capuli has said, if we buy gold through foreign exchange, it will actually just change the composition of the GIR and not increase it.
Sige, go ahead.
Moreover, Your Honor, aside from the fact that there's a dramatic increase in our volume of gold, as far as the taxes are concerned, it appears that there was also a dramatic decrease in the amount of taxes that the government was able to collect from the small-scale miners. From a high of around 205 million in 2011, it's now down to around, I think, around 50 million. So it appears that it doesn't really benefit the government to tax small-scale miners. So we are looking at two components of the tax code which can be amended to favor small-scale miners and ultimately favor the government with respect to increasing its gold reserves, which is amending the excise tax by exempting small-scale miners from excise tax, and at the same time amending the income tax law by excluding income of small-scale miners generated from sale of gold to the Bangko Sentral ng Pilipinas. Basically, that's our position, Your Honor.
The DOF and the BIR.
Mr. Chairman, I think
Dispute the facts, any of the facts that they presented regarding the decreased collection and the decrease in the sales of gold to
yeah,
the
I
BSP.
think that there was a decrease in the sale.
So yung figures, tama? Tama yung figures nila?
I have to validate them, but the trend has really gone down. Yeah.
It's really gone down.
Yeah.
Ano yung figure nyo, sir? Can you repeat it? From how many 100 million to...
Okay, Your Honor, with respect to tax collection for in the period 2011, July to December, the BIR was able to collect 205.4 million. However, when they enforced this excise tax and strictly excise tax, the amount dwindled to only 36.7 million in 2012, and henceforth it's hovering at around 36 million pesos. So if we look at it from a practical point of view, actual collection, we are looking at a very much reduced collection. At the same time, there is a reduce in the amount of gold that we are buying. So
Galing saan? From 200 million?
200 million per in a 6-month period, it's now down to around 36 million.
Why did you make it a 6-month period? Because what was the highest collection na lang?
Highest collection.
Ano yung highest collection in any given calendar year?
Sir, the highest collection was during the 6-month period that it began. It began in July. So July to December, 205 million. The years after that...
No, but previous to that, that was 2011, July to December.
There was no collection prior to July 2011.
Okay.
So
The totally new
lahat,
imposition.
nakakolekta pa sila.
I see. Okay. So 2011, 6 months, 200. 2012,
36.
2013,
around that amount.
36 then.
Around that, yeah.
2014,
Yes. It's already plateaued to around 36.
mga 30 then.
Yes.
Okay, so its comfort level is 30 talaga.
So actually, it's a very small collection.
It's
if we look
plateaued
at
at... so, yeah. Okay, Yusek, the background. Maybe you could... The first thing you could do is, for us, is verify the figures, whether now or in the future. No?
Based on our figures from the Mines and Geosciences Bureau, in the gross value of production in mining from small-scale gold mining, I think based on BSP figures, was 34.6 billion in 2011. In 2012, it was 2.3 billion. In 2013, it's 1.1 billion, and for 2014 is 1 billion, Mr. Chairman.
That's for what?
This is the gross value of gross production value to mining.
Is that small scale? Just small scale?
Small scale.
Gross production. You got those figures from where? The industry?
From the
DNR?
mining industry
The DNR?
statistics, DNR. Perhaps DNR can validate this.
Okay,
kasi
so those are the figures from DNR. So based on that,
bumaba talaga. Bumaba naman talaga.
really, yung collection figures muna natin ang unahin natin. Tama ba yung sinabi nila? Yung 30 plus million a year from a high of 200 million for the half year of 2011?
Maybe we should check our figures. Kasi iba
Sige,
yung figure
after this,
na-
you check na lang your figures and then give us what you've agreed upon, no? And kasi mahirap din if your premises are different, as you know. So, but what's your comment on the bill? Given that your collection is just the 30 million
Mr.
level.
Chairman, it's we have the same position as we had in the House.
Nag-hearing na kayo sa House?
Nag-hearing na kami sa House and we essentially said that we should not mix fiscal and monetary policy. In the case of, for example, one fact, according to our... Kasi I think the root of the problem really is that there is a provision in the small-scale mining law which says that they have to sell only to the BSP at prices comparative with those prevailing in the world market. Now, according to our discussions with the IMF, the Philippines is the only country that mandates this. To be at par with international practice, this mandatory selling to the BSP can be removed from the law and allow small-scale mining to sell in the market. In this manner, the government should be allowed to continue to impose the excise tax without intervention from the BSP. On the issue of it enables BSP to build up gross GIR by buying domestically using pesos, I think they should be balanced with the fiscal goal, but I think there was a clarification that it actually just changes the composition, if I heard it correctly. And one of the arguments raised also is that the gold refinery facility is currently operating at below capacity, and with the contraction of volume, may have to raise gold refining charges. Again, Mr. Chairman,
Very sorry to interrupt you. Before you leave that point on changing the composition, who said that? Could you explain that? We're paying in pesos, di ba?
But in terms of the GIR is composed of gold.
Yeah.
We also have them in our foreign exchange assets of the BSP, and also our investments in foreign securities. Now, if we, as
What
the
do you
BSP,
use to pay for the gold? Does it come from the GIR? The money you pay?
yes, if we have to buy it.
That's why you're saying it just changes.
Yes. It will just change. That's why it will just change the composition.
In pesos siya. Pero pesos siya, part of the GIR.
A GIR is in US dollars, so if it's in foreign exchange, so if you use that foreign exchange
Okay,
to
so
buy that gold,
What was
it
the
will just
statement?
change that.
It's peso. You use pesos to buy it.
Actually, if you want to increase our GIR, as I said earlier, Your Honor, if you have pesos, immediately it's convertible to gold, and that's foreign exchange. Good as say foreign exchange. Now, if you want to increase our GIR by buying gold, then we have to use foreign exchange. If you want to buy gold outside, then of course, nobody will sell you gold unless you use also foreign currency. So this is the cheapest way by which we can increase our GIR. At the same time, it is within our control because we simply buy from the domestic market. And other countries, in order to increase the GIR, there is a time when they have to compel their citizens to turn over their gold to their country, like in South Korea. During the crisis, they were encouraging the citizens to sell their heirlooms,
When was
their
that?
gold. During the Asian economic crisis, Your Honor, South Korea, they asked the Koreans for patriotism by turning over to their central bank their gold jewelry, and the citizens responded. So the point that we are illustrating is here is gold in our country available to the central bank to form part of its reserve. So why are we allowing it to just go away to other countries and being smuggled? So the government doesn't get anything out of it. And at the same time, we are not helping our small-scale miners, because what is happening right now is that instead of selling to the BSP, which will pay them in accordance with the standard market rates, they have to sell it to third parties who do not report this and buy it at a very cheap price.
With
So,
the risk of getting caught.
yes, Your
With the
Honor.
risk of getting caught.
So I think it will help it will also help our small-scale miners. And according to our figures, we're looking at around 500,000 people who is involved in one way or another in small-scale mining.
Okay.
Mr. Chairman, the excise tax essentially is essentially some sort of royalty as a return, because the state is the owner of the resource. Now, right now, if you're not small scale, you still have to pay the 2% excise tax. Now, if the unintended effect, maybe if you exempt them, is that there will be,
The excise tax specifically on mining.
yes, on
Not
gold,
the
yeah.
excise tax in general.
No, on mining, Mr.
On mining
Chairman,
lang.
on mining. So, ang mangyayari dyan, kung i-exempt mo, essentially, the other companies which are not exempt from excise may document everything as small scale. Now, the other complication here is that BSP doesn't really buy from the small scale per se, kasi they buy through traders. That's why
It's like you're laundering you're laundering the gold, parang ganon.
kasi there's, even in a hearing in Congress, there was a proposal from the scale miners to increase their purity, was it purity, or the amount that they were going to buy.
You're
But
saying it will be a tax shield, a tax haven, parang ganon.
magiging tax avoidance mechanism essentially, Mr. Chairman.
Okay.
And it would also be unfair for the big miners, because the the big guys pay the 2%, but the small scale don't. So it essentially has an incentive now to increase small scale mining, which as we know as detrimental. I mean, they don't practice less regulated, and the bigger firms normally practice good mining practices. So yung pollution doon is not is much less. So in fact, under the small scale miners are supposed to sell to the minahang bayan, but hindi naman nangyayari yun. So I'm not exactly sure whether this is the right path. It's like you have a problem of pilferage. Bigay mo na lang lahat ng stocks mo kasi may pilfer, might as well give it away. So I'm not sure exactly whether this is the right approach to it, Mr. Chairman.
Okay. Can we hear from Mines and Geosciences?
Yes, good afternoon, sir.
Hi.
Mr. Chairman. We just will reiterate our earlier position when the same bill was being deliberated sa Congress po. So we defer our position to the our colleagues from the Department of Finance po.
Kung ano sinabi nila, yun ang position niya.
Yes, sir.
Bakit?
Actually,
Dapat you have a unique view as the agency that regulates the mining industry, di ba? Tama ba yung sinasabi nila na magiging tax haven? Kang gagawin ng malalaki, ibenta na lang yung gold through the small scale dahil exempt.
no, sir. Actually, this is more on usapin po ng tax. And so, yung position po ng MGB, we defer it to the Department of Finance. However,
pero may position sila that doesn't particularly just refer to tax. It refers to behavior of miners, and
yes,
as the regulator of the mining industry, kayong makakalaman kung mangyayari nga talaga yun. I think it's possible based on what Yusek Paul, ano tingin mo doon?
Yes po. Kaya po ang MGB, we're doing some reforms. We have actually, nagpalabas na po kami ng Department Administrative Order to amend the rules and regulation ng RA 7076 po. This is po yung bagong rule na DMO 2015-03 na i-confine na lang po yung mga illegal small-scale mining into a minahang bayan. So, para makapture po natin yung benta ng gold, nandoon po yung buying station. We will establish it. We are proposing to establish a buying station doon po sa mga loob ng minahang bayan. That's all, sir.
That's it?
Yeah, po.
How about the Chamber of Mines?
Mr. Chair, we view with concern the proposal to exempt small-scale mines or miners and traders from the payment of excise tax and the creditable withholding tax. As was noted earlier, there was a drastic drop in gold purchases by the BSP in 2012 when the BIR strictly implemented 7076. No? But if we note the production values prior to the implementation, we will see that on average, the small-scale miners accounted for about 30% of the country's total gold output. That's about 40 billion pesos a year. Are we willing to give that up? No. The problem with small-scale mining is the regulatory setup for small-scale mining under the RA 7076, which incorporates a provincial or city mining regulatory board, is suspect primarily because it's basically headed by the governor. No? So the PMRB or CMRB is very politically laden. So it's suspect. And So, when we exempt small-scale miners and gold traders from taxes, it may or may not lead to an increase in gold sales to BSP, given that alternative routes have now been set up, which effectively diverts 40 billion pesos worth of gold to the gray market every year. As a highly portable and
Why 40 billion pesos? That's 30% of the total.
Yes,
gold.
sir.
40 billion.
Yes, sir. That's our rough estimate. As a portable and fungible good, gold is relatively easy to spirit out of the country. No? So, what is the incentive for small-scale miners or gold traders to go back to BSP now that they've established markets abroad? More likely, this will become a tax haven. More miners will now go into small-scale mining or go into illegal mining, because there's really no difference now. Both are essentially exempt from taxes. I think if we really want to get to the root of the problem and to find a solution, let's invite the small-scale miners, the gold traders, and the mineral processors to this hearing so that we know why they're not selling to BSP and what we can do to encourage them to sell to BSP. Like I said, going by historical data, small-scale miners accounted for about 28.3, even going as high as 35% of the country's gold output. This, of course, is derived only from BSP data and only accounts for gold sold to them. This does not include gold which is already being smuggled outside, even prior to 2011, which we believe is also a significant amount. But if the regulatory and monitoring procedures were already in place prior to BIR's implementation of their policy, excise taxes collected for 2009, 2010, and 2011 would have amounted to around 2.2 billion, or an average of 760 million pesos a year. Like I said, are we willing to forego that, given that gold is a finite resource which belongs to the state and effectively to everyone, to everybody, to all Filipinos? Second point, sir, is that the majority of gold sales to the BSP is not done by the small-scale miner themselves. They are done through gold traders that are neither poor nor marginalized. No, they are ordinary businessmen that are making a considerable profit from the work of small-scale miners. They have virtually no overhead, and yeah, they're really making a killing. No, they buy cheap and sell high to the BSP. Exempting them would be, it'd be unfair for other miners that comply with the law. Now, how do we improve gold sales to BSP without having to resort to tax exemptions? We propose that we improve the regulation and monitoring of small-scale miners, gold traders, and small-scale mineral processors, those operating the mom-and-pop ball mills in their homes. Let's have a central registry or database so that we know exactly where these ball mills are, how much they process every day, so that we know what are we missing. Diba? In the last EITI meeting we had in Davao, the MGB regional office there reported that they had cited some 1,900 small-scale mining tunnels or foxholes in Compostela Valley, Diwalwal. But that's just your typical 1,900 holes, tunnels. But that's just your visual inspection. That is not complete. So we need something of a central registry or database for small-scale miners. There is currently none. We do not know exactly how many they are.
Then yun, engineer? Gawa tayo ng registry?
Yes, Your Honor. Currently, yung po nga sa ating bagong DMO order, they will be confined into a minahambayan.
So lahat ng small-scale miners will be minahang bayan?
Yes po. It will be declared from certain provinces na i-declare po siya as minahambayan. Then lahat po nung operating small-scale mining na will be declared as illegal po.
Na hindi na-declare.
Yes
Who
po.
is not,
Yes po.
so any of the 1,900 na hindi nagpa-declare ng minahambayan,
They will be
illegal
considered
yun,
illegal
na yun.
po.
Okay. Naumpisa na ba yung proseso na yan?
Yes po. Currently, we have already 3 operational declared minahambayan.
Saan yan?
3 area po to. Isa sa Diwalwal, sa 2 po sa Mindanao po. Sa South Cotabato. Isa.
Saan yung dalawa?
Sa 2 po sa Mindanao po. Sa South Cotabato. Isa.
Saan yung dalawa sa Mindanao?
South Cotabato po isa. I cannot remember the other one po.
Okay. And you're planning to process. Anong involved doon sa process na being declared minahambayan? Anong paperwork? What do you have to comply with?
Sir, certain province has to apply for a mineral or minahambayan.
Yung probinsya nag-apply?
Apo, probinsya or city na gusto kong mag-apply ng minahambayan. It will be processed at the central office. And titingnan din po yung kanyang status if could be declared as minahambayan.
Eh kung yung governor involved sa mining, hindi siya mag-apply kasi kumikita siya doon.
Opo, but kung yung operation niya po is not included in the minahambayan, it will be declared
magiging illegal siya.
Magiging illegal po.
So when is your target to implement?
Currently,
sa ngayon ba ibig sabihin na kung hindi well, I'm sure may target date yan na yung
Yes
cut-off.
po.
After that kung hindi ka illegal ka na. Kailan yun?
Ongoing na po yung mga pagre-review ng mga minihambayan ngayon. We have at least 15 to 20 application for minahambayan. And we are facilitating the processing of this minahambayan para makapagsimula na po tayo ng ating bagong IRR nung 7076 po. Ongoing na po yung mga pagre-review ng mga minihambayan ngayon. We have at least 15 to 20 application for minahambayan. And we are facilitating the processing of this minahambayan para makapagsimula na po tayo ng ating bagong IRR nung 7076 po.